When we look at the attorney fees that were requested, again, one of the ironies to all this is those attorney fees also included fees for the investigation that the lawyer performed. There's not a doubt that it was an investigation, that it was sufficient in good faith. Question is the evidence and the burdens that are before the trial court, and the evidence that was before the trial court. And the only evidence was that she was unaware of any investigation. As their obligation, that is insufficient to support and will be an improper shifting of burden. When we look at Nationwide Life Insurance Company, the Court of Appeals has already said that it's the insured who bears the burden of proving by a preponderance that the insurance company refused to pay without just cause or excuse. Not our burden to rebut non-evidence. Yes, sir.
Counsel, I'm interested, you don't have much time left.
Oh, thank you.
And I would like for you to comment about the issue concerning the conflict between the settlement agreement and the subcontractors agreement. Would you comment on that, please?
The substance of the settlement agreement, first off, is not a settlement agreement with my clients. This was a separate agreement between the subcontractor and the subcontractor. We're not a party to it. The court chose to rely on that as its only evidence of the amount for the judgment against ultimately my client.
And what's wrong with that?
Well, I think that number one, that judgment based on the settlement agreement is that you have to accept all the settlement agreement. And that settlement agreement includes within it the release of my clients, but for what is found in the terms of that settlement, which required there to be a demand on the subcontractor. And without that evidence, then there's no liability.
Don't you have recourse back to the subcontractor under your settlement with under the judgment that was granted to that subcontractor of $1.some million?
No, I don't see the court didn't grant any set off, didn't grant any.
Well,
it's a joint and for whatever reason, the court did a joint and several.
The court found
judgment.
McPherson for liable to the subcontractor for a little over $1 million, right?
Yes, that's correct.
And did that $1 million include what was owed to Garcia in this matter?
I think it could have, yeah.
So wouldn't you potentially have, if you're reliable to Garcia under your surety, wouldn't you then have a potential set off against the subcontractor?
As a post-judgment set off, I don't think that that is possible, but more importantly, it is also against the surety. And the surety doesn't have that power to set off from a different sort of judgment. I want to touch on interest for one moment, and that is the same issue, which is that this was a judgment entered based off of a settlement agreement. And when looking at prejudgment interest, you have to look and see, when is it subject to calculation? When is that judgment subject to calculation? Trial court didn't evaluate it according to underlying invoices or liabilities or contractual defenses. It chose to just take the $75,000 from that settlement agreement, which we were not a party to. And it's only at the moment that court entered that judgment that that amount became liquidated, because the only basis was the agreement itself. So the prejudgment interest can only run from the point of judgment, so there can be none.
The is Drywall, LLC. As you have gleaned from the briefs that are filed before you, my client is a small family-owned drywall company. They were a subcontractor to Smithson and Inwall on 2 commercial projects located in Johnson County. One was called the View, V-U-E, and the other was called Iron Horse. Smithson was a subcontractor to the general contractor McPherson in this matter. And my client performed drywall hanging and taping and sanding on the project. The evidence that was presented to the court was that work performed by my client was proper, but we were unpaid. So they left the projects. They left both projects. Garcia's filed mechanics liens and then made bond claims on the payment bonds that had been issued by Fidelity, the surety in this case. McPherson then bonded off those filed mechanics liens using those bonds, which turned them into statutory bonds that were filed. The case was tried in January of 2024 before Judge Winnell. The court rendered a decision about 12 months later in December of 2024 and issued 156 separate findings of fact and conclusions of law. We've attached those findings of fact as Exhibit A to our brief. The judgment was entered in favor of Garcia's for $75,000 plus interest and costs. The court also awarded attorney's fees of $85,000 to the Garcias and entered a judgment against Smithson for approximately $1.12 million. McPherson and the surety settled with Smithson, but they have not settled with us. So in this case, the appellants have now appealed that decision. We've set forth what we believe to be the 5 issues before this court. The first issue is the judgment for $75,000 that was entered against Smithson and Fidelity. We believe that should be affirmed. The standard before you is one of substantial competent evidence. The district court, contrary to counsel's argument, accepted a stipulation that Smithson agreed it owed $75,000 to Garcia's. The court entered judgment on the statutory bonds in this case. The appellant's brief doesn't seem to address the issue of the $75,000 judgment against Fidelity. We consider that issue to be waived or abandoned, and it should be affirmed. Regardless, there is substantial competent evidence to support that finding. Fidelity issued 2 bonds which were filed by McPherson to get rid of the mechanics liens that Garcia's filed on each project.
Counsel, I'd like for you to address the attorney's fees issue, if you could. That, and then also the prejudgment interest. Because my question is on prejudgment interest, if you don't have a sum certain, how do you compute? If you don't have a starting date, if you don't have a sum certain, how do you compute prejudgment interest? And I'm curious about how the judge approached that.
Very good.
And explain why that is an error.
All right. I'll start with the attorney's fees issue first, because it was kind of raised in 2 ways. I've seen over the years a party who is stung with an adverse result at trial seeks to blame others for their own misfortune. That's exactly what we have going on here. The claim of attorney's fees, the trial court basically we presented evidence at trial that was essentially undisputed, that the work was performed, the amounts that were due. We introduced copies of the liens that had been filed. Again, none of this was a secret. And Garcia's also presented evidence of the demand letters that had been sent to Fidelity and that amounts were never paid. The witness that counsel complains of is a lady by the name of Diana Garcia. She's the foreman for Garcia's Drywall. She ran both of the crews on the View as well as the Iron Horse project. When asked whether she was aware of any investigation, she said no. And I think she answered honestly. But you have to consider the context of where the question was asked. There were 2 defenses, and only 2 defenses, that were raised by Fidelity and McPherson as to Garcia's in this case. One was a defense claiming a lack of contract between Garcia's and Fidelity, and that second defense was that the work done by Garcia's was somehow defective on each project. Diana Garcia testified about the settlement that was reached, and she testified that in May of 2022, there was a settlement reached with Smithson for the sum of $75,000. Fidelity was aware in May of 2022 of that settlement. At trial, McPherson and Fidelity presented no evidence of any investigation made on the statutory bond claims, and more importantly, no evidence of the defense of defective work, which was one of their primary defenses in this case as to Garcia's. Now, clearly they had an opportunity to do so. They didn't do it. They had an opportunity to cross-examine Garcia's witnesses. They didn't do that either. They actually had listed in the pretrial order a witness that they were going to call to testify, but for some inexplicable reason didn't. So instead, The appellants, their strategy in this case was they claimed no contract existed between Garcia's and the surety, and therefore, and they also attempted to rely upon discovery responses that they have attained from Inwall and Smithson 9 months after the claims were submitted to support the claims of defective work. In other words, they looked at something 9 months later to support their claimed investigation as to defective work. That was the only 2 defenses that were raised in this case. And as we've seen, the district court judge, Judge Winnell, found that the bonds were statutory bonds, and he invoked judicial estoppel against McPherson and the surety to prevent them from claiming otherwise that these were anything other than statutory bonds. Well, why did he do that? He did that because, remember earlier, they had used these bonds to bond off the mechanics liens under the statute, yet at trial, they claimed these were not statutory bonds. Judge Winnell saw through that and said, no, they are statutory bonds, and Garcia's followed the statute and made a submissible claim. Now, as to the second defense, I think this is important because it ties on the issue of attorney's fees. The issue was the court held there was no real question about the quality of Garcia's work on the projects. That's on page 22 of his opinion. The court also held that Fidelity performed no inquiry at the time of the lien filing as to the quality of Garcia's work. So what do we have here? We have then late filed evidence and testimony that was submitted over a year later of the claimed investigation that isn't in the trial record. And they want the court to look at this late evidence, but the court looked at it and said, well, this isn't classified as new evidence, and you didn't raise this. So as to the issue of attorney's fees, the court found were reasonable. The district court found that the claims under KSA 40-256 weren't new and were raised in the pretrial order, and they certainly were not a surprise to the parties. The district court reviewed the time entries, reviewed the factors under Model Rule 1.5, and district court took into account the length of the trial, the legal issues that were raised, and the time and labor involved. Interestingly, the court also noted that the amount sought in attorney's fees by Garcia's was less than the amount originally sought by Garcia's in total for both projects. In other words, he found that those fees were reasonable. Now, the allegation here is that somehow this witness misled the court, or there's not enough evidence here to support the investigation. Well, there is no evidence before the court that was introduced of any investigation as to the quality of the work performed by Garcia's. And why is that important? Because that was one of their only 2 defenses that was asserted against Garcia's. And so the court found that they failed to satisfy their burden of proof as to the affirmative defenses they raised. Those are negative findings. And I think that there's a specific standard with regard to negative findings made by a trial court, and that standard should apply here. They want to ignore the district court's specific findings in this matter. Now, as to the issue of interest, Judge, you asked about that. We believe that the standard is abuse of discretion on computing the interest. The district court awarded prejudgment interest to Garcia's for the time period April of 2019 through July of 2024.
My question is specifically, how do you get that starting date?
Well,
Is that just picked out of the air arbitrarily? Could it have been 3 months earlier or 4 months later?
no, I think the specific starting date of April 18th, 2019 ties directly to the final demand letter that was sent on the Iron Horse project by Garcia's. Again, the interest was assessed.
The court didn't say so, did it?
It did. It specifically pointed out in its findings that Garcia's made demand on Fidelity on February 15th of 2019 on the View project and on April 8th, 2019 on the Iron Horse project. So in essence, the court took the later date, not the February date, but the April date, in order to compute interest in this matter. That's where that came from. There's no dispute the court computed interest at 10% per 16-201. And so the funds were due from Fidelity from the date of that last demand letter. That's where that came from.
All right.
So, Your Honor, there's other issues that have been raised. I don't want to belabor the point on those, but we believe that the attorney's fees were reasonable. We don't believe that there's been any misleading of the court in this matter. And the new issues that were being sought to be raised were not raised before the trial court in this matter and should be disregarded. My client, Garcia's Drywall, has waited now 8 years for its money on these two projects. That's a long time to wait for a small family-owned company for their money. We'd ask that the court affirm the decision of Judge Winnell in all respects. Thank you.
Rebuttal. Thank you. I would ask you to just take a look at the actual record and the pretrial. I do want to talk about the pretrial for just a moment. I think it's interesting to note that as far as the pretrial goes, we have our different contentions by statute, as far as what's within that and the initial contentions that are within it. And during our pretrial conference at record 2, page 14, his comment, the judge's comment about those contentions is he lets anybody say whatever they want. And that doesn't guide him substantively, that those are just say what you want. And what mattered to him was then the substance, again, record volume 1, page 208 and 209, where the court is specifically saying that this is an attempt for a judgment based off of a $75,000 stipulation between the parties under a settlement agreement, which, you know, in that perverse lawyer way, kudos to them for having a change of position after 4.5 years and 5 weeks before trial and a 5-year piece of litigation, decide that they're going to try to change the entirety of all their testimony. Because the fact of the matter is, and probably more of a legal issue than you should wrestle with in this case, is there are admissions which specifically say that this money is not due and owing to Garcia's. And that admission is by the person who would pay them, which was the subcontractor, Inwall. And 6236 talks about not in terms of that being an admission between parties, but that is an admission in the case as a whole and is dispositive until and unless the trial court allows it to be withdrawn. They never asked that, have that done. That was never done. So touching on one of the issues that counsel raised, there was a lot of evidence, and we put that in our brief. In fact, beginning at page 9, listing through the evidence, which was before complaint was made, before claim was made, after claim was made, conclusive as to facts under admissions, that there was.
But you can't use the admissions in the litigation to justify an investigation before the litigation started.
We're not trying to here.
Well, that's what it appears.
No. I'm simply responding to this notion that there was no just cause or excuse that existed. And in fact, the evidence was there. As far as the trial court was concerned, our water wasn't wet. And we couldn't do anything in that courtroom, apparently. So we're not here to reweigh that, but nor should you put weight into the attorney fee issue that there was literally no evidence of a lack of an investigation. And that's not a negative finding because they still have the duty to come forward with evidence.
How can they prove that your client investigated?
Well, first off, we know that counsel knew that there was an investigation. So leaving that aside, it's pretty easy. What you do is you go forward and you say, we made a claim, we followed up with it, we asked for a response, but they couldn't, and we received no response. They can't say that because that was not true. And yet that has been allowed to percolate through the opinion as well as the order to the prejudice of the parties in this case, a lack of evidence, and that requires a reversal. And I thank you. I'm sure everyone else will join in just thanking Judge Hill. I hear your retirement is forthcoming. I'm a bow tie for you.
Yeah, thank you. High noon on January the 11th, I think,
Oh.
when my term ends. All right, thank you, counsel. We appreciate the arguments on a very interesting case. We will take the matter under advisement and issue a decision as soon as we can.
Thank you.
Thank you.
Thank you.
Thank you.